Still listen.
Check out then.
No. Still listen because, well, you guys are interested in it because you mentioned it last time. The America Invent Act. First thing I thought was interesting about that is if you just Google the AIA.
It should be architectural something.
Right.
Because I used to do AIA buildings.
Right. So, yeah, and as soon as I saw the abbreviation for it, I'm like, that sounds familiar. This is, one of the things you have to contend with. So, any of these terms that you search for, there's probably half a dozen or more organizations already out there that use this name. Right? So you have to zero in on the right one. I mean, even aerospace industries. So I did put in the course a couple links. One of them that you had mentioned to me, and then another one. And this link right here actually takes you to the text and PDF of the act itself. Again, not on the quiz. If you're really into it and you want to read the actual act, go there. Only if you're really into it. This link right here is not a bad link. I know somebody mentioned that they went to Wikipedia, and it looked like that site has some outdated information in it. But here is the actual site that the government uses to kind of share information about the act. So if you remember last time, we were talking about patents, and we had a discussion about who wins in a contest, right? Who invents it, who applies for a patent, who gets the patent, right? And did anybody remember what we decided? What the answer was?
So whoever applies for the patent first.
Right. Well, close. Close. So what we're talking about here is any one of your products. Let's pick group number 2. Right? It's a product that creates fuzz instantly. So you come up with it, and you're seeking patent protection for the formula, process, and whatever it is, right? So there is, the choices could be the first two, invent. So how would you establish that?
Maybe by showing maybe drawings or your product or early ideas of it, or
Right. So
proof that you've been working on it.
what are the problems with that?
You have to show when.
Right, and so which can be a challenge, right? When was the drawing? What are your records? But what's another problem with that? When you guys were saying, you come up with this cool idea or concept, and if you make a record of it, what could happen? It gets stolen, right? So when you're inventing something, there's potential that you're not really running around bragging about it. So there may not be a whole lot of evidence, right? And then later when you say, look, I came up with this drawing and of this date, what could someone else say?
So they did it first?
They did it first, and you just came up with the drawing later of that. So proving when you invented it can be tough. Another choice would be upon application for the patent itself, right? First one to apply for the patent. That's documentation that you actually came up with the idea, and you should win. Another one would be actually getting the patent approved. The last one is gonna be the law. The law has been passed, but it actually doesn't take effect till when?
It takes effect over the next couple of years, I believe,
Yeah.
but it just
Starts in March.
Okay.
So March of this year, it kicks in, and it's the first inventor to apply. See how that's a mix there? So this was a new one to me. I got the whole idea of changing it to the first to apply. But why would they say in this new law here, first inventor to apply?
Because you can't steal somebody's idea and then go apply. You have to prove that you
Right.
actually invented it
Exactly.
separate from them.
Yeah, so we have established an application process, but we also, the inventor's the one who applies for the patent. Well, thinking about this new law, what kind of potential issues can you see that are going to come up?
Proving that you
Right.
actually were the first.
Right. Not too hard to show that you were the first one to apply. So if it was purely just a race thing, you could just say, I got there first because I applied for the patent on this day. Problem is this is kind of a mixture. You know, it's going to be the first inventor to apply, so, yeah.
Isn't, like, I think I took a class a couple years ago where they were talking about the drawbacks to patenting an invention.
Mhm.
Like, doesn't like your formula or whatever become public? Like, isn't that why Coca-Cola never patented Coca-Cola?
Yeah, there's, on this website, if you're really, really into it, like you aspire to be a patent lawyer someday, there's down here at the bottom, or was it? One of these areas, I think it was maybe resources. I am answering your question kind of a roundabout way here. I didn't forget it. This guy right here, he's a patent attorney for, I think, a drug manufacturer. The guy's a genius from what I read. If you read that, Understanding the AIA and its implications, he goes a lot into the history of patent law, but he addresses that question about, well, what kind of system did we have and do we have now? We used to have a system that was more private. So if you had an idea, you wouldn't necessarily want everybody to know about that idea. And then when you get approved, a big unveil, here's my idea, I have a patent for it, I win. Then we've moved more to a system where some of the information is available to this one under this new law. It's really going to change things where everything is public and you all have an opportunity to object and say, no, I was the inventor, right? I came up with it first, or I have some kind of prior art or something. So he goes through that in a lot of detail. So this is going to try to twist the whole system around where, you know, as you apply for a patent, there's lots of folks who can, during and then upon granting the patent, say, you know, because it's public information, I had that idea first. Here's my documentation.
I think it's going to slow the process quite a bit. Because you're just going to tie up something that's invented.
Well, I think, you know, we were talking about last class about this whole idea of how does that change how you practice the law or how you get a patent. I think you're going to have to be doing a whole lot of documentation as you go along in case anybody decides they want to challenge it. Well, why would we do this? Why would we switch from a private system to more of a public one where everybody gets to have a say into it?
Maybe they feel more.
To avoid that's the theory, is that by everybody seeing it, knowing it's like everything else on the internet, you know, let's just make it public and open and everybody's going to get to contribute to it, and therefore the end product, no one's going to be surprised when it comes out, right? Or someone else.
I don't know where I was going. Go ahead.
Well, with our technological advances, there's so many different forms of property and inventions that you can do now. And I'm sure stuff's been duplicated over and over and over again, just a tweak here, like the application process. Instead of cream, it's the pill or whatever, you know?
It's positive.
So, yeah, that too. But there's just so many ways and so little ways. But I'm sure with like this new law where they make it more public, like in order to even challenge somebody else's application for, you would have to come up with a mountain of proof. and documentation.
And money.
And I'm sure
More money
the
for
cost to do
lawyers.
that. Yeah, I'm sure the cost to do that would be almost insurmountable, unless you already have a company where you have several different patents that are already approved and you're making a buttload of money, so.
Right. So even for this guy who's, works for this drug company,
Yeah.
what they make all their money, I say all, but a lot of their money by securing patents on products, and
Well,
they're
a lot of
really
people like
concerned about
to
it.
make sure patents don't happen. Like if somebody comes up with a cure for cancer in their garage, like I'm sure pharmaceutical companies would try to stop them like crazy because they make so much
Right.
more money off treating
There's
cancer.
gonna be a movie in that one.
Yeah.
Someone's gonna come up with a cure, and then they're gonna get killed, right?
Yeah, like what is that Keanu Reeves movie, like Chain Reaction, where he came up with cold fusion? Everybody was trying to stop him or whatever.
Or the electric car.
Yeah, that's it.
So my question is, like, with the new law,
Mhm.
and if it starts in March, like, it can't be retroactive, right? Like, you can't be like, well, they said before that I couldn't because I wasn't the first to apply.
Yeah,
although-
there's kind of a frequently asked question of this site that goes through a lot about, what about a invention or idea that I claimed prior to this, or, like, now there's this transition period between when they passed the law and
Right,
March.
that's what I'm
Yeah.
saying, like,
Yeah, so
How does that-
they've anticipated that, and there's some answers to all those questions on the website. To me, I'm thinking the law is a law now, but doesn't take effect until March. Well, then that has to mean that that wouldn't be the process until March. So you'd adhere to whatever the current law is in terms of the priority that's given. But they go into more detail about that. Anyway, just because that came up as an issue in class, as I teach this class and then get past that March date. So the rest of the semester, after you get back from spring break, then we'll have different law that applies to it. I don't know, I just think it's interesting, like even the Amazon one-click thing, and what your question was about the amount of information that's available. Amazon at one point patented the one-click process, right? It takes years to do, and then, you know how the one-click process works? Just one click, right? You have a product, you click on it, it's got all your information already. And it would be just like you go to Shark Tank, right? And there's this whole panel, and you go, I got an idea, here's my idea, just one click, right? What's the whole panel say to you? They get angry. What do you mean? You can't patent the click process. Everybody's doing that. That's crazy. You can't license that to other people. That's what happened. Amazon got a patent for the one-click process.
There was a big thing about the shopping cart. He put it up, there was a guy who put it up on his website before he did anything with it, just the shopping cart process, and then went through all kinds of lawsuits and everything because everybody took the shopping cart thing. And to be able to keep, instead of paying for one thing at a time, he came up with a process where you could put one thing on a separate file and then keep shopping. And then that was a big, big deal for a while.
Yeah, and even with the Amazon one-click, the patent office came out later, after they decided that others had infringed on that patent, and said that that couldn't be patented. Now I think they went back again and they're looking at it again.
Yeah.
So, anyway, that is patents. So those, if you want to really get into more detail about it, you can go into the resource folder and get more information. I also put a link to the lecture notes and video for this particular chapter in the folder, but there's another link here also. If you click on it, and this is in your chapter, and notice that it says there may be some temporary issues. I think that's with the technical maintenance, but look for little notes on these websites in terms of whether the information there is accurate enough or not. In your book, what page is that on where it talks about the anti-cyber squatting and consumer protection act?
132.
The ACPA.
132.
Okay. All right, so when you look on that page, and there's a reason I'm going to go to that page also, there's a reason I'm having you go there. Because the issue came up while we were talking about it in our groups. All right, so on 132, right under anti-cyber squatting legislation, it says the ACPA makes it legal to register, traffic in, or use a domain name, one, if the name is identical, which would be like Nike.com, or confusingly similar to the trademark of another. What would be confusingly similar to Nike?
Nike shoes.com.
I think so. Yeah, it's not the same, but would be confusing. And two, if the person registering, trafficking in, or using the domain has a bad faith intent to profit from that trademark. Don't miss that. You may see that in the future, right? Are there other reasons? Because we talked about when we talked about domain parking and someone else having web addresses, that somebody might actually obtain a website beyond cyber squatting, beyond having some bad faith intent to profit from a trademark. You guys follow me? You have to have one and two. If you were accused of cyber squatting, what would you argue other than bad faith intent? What defense could you come up with?
You can't prove intent.
Well, you might argue that I didn't have a bad faith intent, that I was just trying to do everyone a favor, I guess. Yeah. But what other reasons might you secure a domain name ahead of time?
If you're planning on using it yourself.
Right. Not that you were necessarily going to infringe on someone else's intellectual property, but you came up with an idea and you planned on using it in the future. Now when someone accuses you, well, I mean, part of the problem is when you attempt to sell it to someone else, right? You know, oh, now that you come along and, well, we had this idea, but, yeah. Does that happen?
Yeah.
Do you think companies look out there and find web addresses, find out they're taken, and then go buy them? Yeah. Sure. Yeah, it happens. But then notice the paragraph underneath that. Despite the ACPA, which also is Concrete Something Association, look that up online. Cyber squatting continues to be a present problem for businesses largely because top-level domains, TLDs, are now available and many more companies are registering domain names. Indeed, domain name registrars have proliferated. So, examples we mentioned in class are GoDaddy.com. These companies charge a fee to businesses and individuals to register new names and to renew annual registrations. Are you seeing a potential problem here? If your business is now to sell domain names, couldn't you potentially be in violation of the act? Because now your job is to have domain names and then sell them. Well, you could make the argument that that's not bad faith intent. All right, go up to the top of the next page. Every time you come up with a new law, you now have someone who comes up with a newer idea. What's the new idea?
Typo squatting.
Right, which is what? You guys have had this happen before. Google or whatever, and something else comes up. Was it you guys that were talking about Wood TV8?
Yeah.
I did that. Like, it wasn't guys, I think it was girls when I went there. But I was telling my wife every morning gets up, goes to woodtv.com, looks at the weather or whatever, and I said, type woodtv8.com there. Sure enough, it doesn't take you to the
When I was in middle school, it was like whitehouse.com instead of whitehouse.org.
Yes.
And everything like that.
Right, that's been fixed, but. Yeah, so, I'm not sure is even a typo, right? Because Wood TV8 is the name. So, sometimes we get into these folks who register names that are slightly different than the actual name. I give you some examples there of Hotmail and MySpace, both of which aren't doing too well right now. That are just a little different, and people often will type quickly and get them wrong. So we're kind of going beyond just the grabbing someone else's trade name or trademark and making it into a domain to actually being in the business of grabbing domains and just for the purpose of reselling to even slightly different ones. I'm trying to remember if it was in your book, but there's also this whole idea of, well, it's related somewhat to typo squatting. Have you ever been to a website and there's a whole bunch of advertising on it? Like you type the wrong thing, or you go to what you think the web address is, using the name, and it's, what's that all about? Why is that there?
Somebody's cashing in on it.
Right. So somebody goes out there, gets bulk domains that people might commonly look for, and then they just fill them with ads. Was that in here, or did I read that? I'm trying to remember where I read that.
But they do like one of those survey things.
Mm-hmm. Or the other idea is that you have a period of time for securing these domain names and then releasing them. So companies are actually just snatching a bunch of them up, putting ads and stuff on them, and then releasing them again as a type of a business model. All right, so there's that, and I think that's all the links that I put in there. But I just want to pull up the rest of the slides real quick. And I think we pretty much got through, we talked about strong marks versus secondary meaning, generic terms, the different type of service certification marks. I know one thing I wanted to mention was somebody asked a question about dilution. So go back to 133.
Dilution.
Well, that's in the online world, but that's not what I was looking for. It's at the beginning of the chapter. Trademark.
Trademark infringement.
Right, infringement versus dilution, I think was what,
120.
that was the question you were kind of
Trademark dilution.
asking about, right? So notice on page 128, it talks about trademark dilution, and then on page 129, it talks about trademark infringement. Okay. So over on the left, trademark dilution, it says, before 95, federal trademark law prohibited only the unauthorized use of the same mark or on competing or on non-competing but related goods or services. Protection was given only when the unauthorized use would likely confuse consumers as to the origin of those goods and services. Okay. It also indicates on that page that half of the states have also enacted their own state-level dilution laws. The next paragraph, it says a famous mark may be diluted not only by the use of an identical mark, but also use of a similar mark, provided that it reduces the value of the famous mark. So somebody asked a question about dilution and whether that's required or not. You can show infringement without showing a decrease in value, but if you're bringing in an action for dilution, then that is part of that particular action. So I know that want to make sure I got that one straight. Then we talked a little bit about licensing already. Any of you into licensing your product? It seems like Sunblock probably would license their product. I'm not so sure about the other two there. And let's make sure I got it. So the second part is around the digital information, digital rights, and a lot of this is related to what we've already talked about in terms of, we're talking about copyright here. But digital media does bring up some new issues. I just wanted to touch on a few of them quick. We talked a lot about how copyright covers expressions of ideas in some kind of media in terms of writing a book or whatever. Here, as we get into digital media, here are some other issues that come up, right? Like, how many of you have records? You know what those are? They're circular, and often they're black. And vinyl, is that what we call it? Okay, that helps, yes. So, not so many of you know, like my kids would probably have no idea what that even is. How about, like in your movie collection? Is your movie collection DVDs or is it digital? Or maybe a mix
DVDs.
Yeah.
I know that. My Disney movies on VHS.
Oh yeah, I forgot about that. There's tape, right? Like somebody will ask me, "Can I tape record your class?" And I'm like, "Really? You do that?" So they're still out there. People still do them, but I think we're probably much more into digital recording or web-based recording of some kind now than this. Even right now, I'm recording the class. I'm not recording it on reel-to-reel recorder of any kind. I know. You'd think I was based, like a big deck right here. Some kind. So as we move to more digital media, I mean, we start streaming. You mentioned .tv. We start streaming our content versus actually having some kind of physical media. We still have these issues we have to deal with. And notice it says up there at the top, it makes it easier to copy. Right? Those physical media, they always try to put things in it to prevent you from copying. They certainly do that in the digital world, right? Like if you have something that plays in iTunes, and buy it in iTunes, it doesn't necessarily play anywhere else. Right? Is there a way to circumvent that?
Oh yeah.
Oh yeah. Right. Yes, there is. But for you to do that, or for you to tell someone else how to do that, so don't, is a violation of the law. It's too late, huh? So anytime a copyrighted work is downloaded and stored in RAM or hard drive without permission, there is infringement. I just point that out because I have this discussion with online students a lot. Like, they think, well, if it's free, if it's out there, and I can click on it and download it, then that's not an infringement. Or the reverse that I hear quite a bit is, if I pay for it, then therefore I haven't infringed.
Depends on where those profits go.
No, it's not the measure of where the profits go. It's who you're buying it from.
Well, like say.
I think we're saying the same thing.
Yeah, I pay for iTunes. But iTunes pays the artist that I buy from.
Yes, so they may have royalties that they pay.
Yeah.
So, is it possible that you could find infringing work on YouTube, iTunes, or anything else?
Oh.
Yes. Like the one I have heard this week a lot is Glee. Jonathan Colton came out and said that Glee had ripped off a song that he had done, but he had actually taken the song from somewhere else. Right. But there's these things where you hear something or you see something, even a production on TV doesn't necessarily mean that they have the rights to do it. Right? So the fact you pay for something doesn't mean for sure that it's properly licensed. Right? You could pay for something that's bootlegged and sitting in a store somewhere. In fact, we mentioned that last time. There's a lot of things that are counterfeited. Like when they say 6 or 7% of the stuff sitting there is probably counterfeited. It's not actually work that's properly licensed. And then, here's another example of even putting something into your computer memory or RAM of some kind could potentially be holding on to, we've got to change our laws a little bit as we get into these types of issues. Last one, right here at the bottom, that comes up frequently is the fact that an author gives somebody permission to sell their book. Does that mean that they then are giving them permission to sell the ebook version of it or some other version of it?
Well, wouldn't it be all forms of that publication?
Well, if you're right, if you're an author, you would want to make sure that you got control over all those different things. If you're the one who's publishing the stuff as an ebook, you might claim that you do. But bottom line, what do we need to do here?
Have it written.
Right, we need to make sure that if we're going to, in these days, license media, that we not only take a look at how it was actually, what media it was put in, but what we could be putting it in, and then what's potentially going to happen in the future. All right, we're out of time. We'll stop there. And remember, you can take the quiz online before next class, or you can come to class next time and do it in class.